been a wonderful friend and supporter of our DRC for a very long time. He is a retired attorney. He's a mediator, civil and domestic relations, and he also did the peacemaking training some years ago. Um, and he's also served on the DRC board, including as board president for a period of time. So Joe and I have worked very closely together on the sensitive information regarding the DRC, and he has been a supporter for a very long time, and I appreciate I appreciate that support. He was very helpful to me as an executive director. With the group, Joe, would you like for us for anyone to introductions of some sort? Would that be helpful to your presentation?
No, I
Or,
mean, I don't think so. I mean, unless you have something special in mind. I mean, I recognize and know most of the troops, or
okay,
seen them at
just want to make sure.
one time or another. You know.
Yeah. Well, I wanted to just to kind of help us shift into the presentation mode, lunch and learn mode. I was going to ask folks an opening question. Um, the question is, what excites you about the spring? Put your answer in the chat, and on my count of three, we'll hit the enter button and have a cascade of answers around the same time.
What excites me about what?
Spring, what is it? I'll put it in the chat. What excites you about spring? So,
Sure.
thank you all for your response and for participating in that. And I'm going to turn it over to Joe, our speaker for this afternoon.
Okay. Thank you. Let me. I'm going to pull up. I need to. Uh, I should be able to.
You did.
You all get the desktop here now?
Yep.
Yep.
Yep,
Okay.
see it.
Um, let me. I want to put the. Let me set the context. Um, I quite frankly don't forget where we left off last time. Last time I talked about this, although I do remember that we didn't make it through all of them for a variety of reasons, and we probably won't do the same again today. Um, but I wanted to kind of initially set the context and maybe address a couple of these that come up all the time, and maybe a little bit more, um, maybe more useful for that reason. Um, I would, if anybody wants to jump in, or if you have any questions at any time, don't feel free to interrupt, because I think it's important for us to interact and share experiences or observations about these traps, because they do come up again and again, not just in our work as mediators and negotiators, but in everyday life, just dealing with friends and family and people on the street. So don't be afraid to jump in. Here the context for this is, let me go to number one first. The people who get the lion's share of the credit for this work, and knowledge of these traps has become fairly common, I think, particularly over the last decade or so. Most people accept them, and are willing to try and learn to work with them. But they originally came about in the 70s and 80s as a result of research that Daniel Kahneman and his partner Amos Tversky had done. They basically come from a cognitive psychology background or social economics. There's a number of ways of describing their scientific discipline, but it basically applies cognition and behavior to economics. That's how they started out. Um, and they won a Nobel Prize in 2002 for this work, for actually coming up with this list and pioneering the work, which has become known as the top 10 psychological traps, also known as the heuristic devices, a fancy word for shortcut. Simply to describe the way that we as negotiators and mediators and folks in everyday behavior use shortcuts to navigate relating to one another. So that's the kind of the deep background in terms of the history. But to provide just a little bit more context, and this also comes from Kahneman's work done more recently. He published, I don't know what the copyright date is, 2011. He published a book called Thinking Fast and Slow, which became a New York Times bestseller, and kind of puts all of these traps into a more meaningful context. As a result of the research that he and Tversky did, Kahneman came up with really the structure or way of framing this that makes it easier for people to understand and what's going on and to understand their own behavior. And he basically breaks our responses down into two systems: system one and system two. System one is that part of our brain, if you will, that operates very quickly, very intuitively, relies upon the reptilian part of the brain, if you will, that which is responsible for the flight or fight response. That characterizes, in simple terms, system one. System two is controlled primarily by the prefrontal cortex, the frontal lobe, that part of the brain which engages in judgment, thought, is capable of discriminating analysis, operates on a much slower time frame. And this is, we're not talking about fight or flight. We're talking about more thoughtful, deliberative, cognitive analysis of a given problem before we engage in the behavior. The top 10, the traps are largely system one responses that operate almost automatically, intuitively, and quickly without any conscious thought on our part. Kahneman taught that both the fast and the slow work together, but because of their speed and utility, our instincts, the fight or flight response tends to predominate, and really has an evolutionary origin. We're all familiar with the old saw about bad news travels fast. That has its origin in our evolutionary need to be more cognizant of dangers than we are of positive opportunities in order to maintain the species. Another, while I commend Thinking Fast and Slow to your reading, You're probably also familiar with some of Gladwell's work and Blink and a couple of other books that talk about quick experience-based decisions. These come from the same, born of the same part of the brain that the top 10 traps are. And the challenge is to moderate the intuitive and quick decisions in a way so that you check, although they often they're very helpful and necessary in navigating everyday life. They sometimes produce biased and flawed outcomes if you don't bring more serious deliberation to them and take the time to analyze what's going on. The problem is that's hard work. And we've all had experiences in mediation, either participating or working as facilitators, uh, where decision fatigue sets in, and you recognize how difficult it is, particularly in a more complex negotiation where there are a number of issues involved. Um, it taxes the parties. And we can come back to some of the lessons there, what we need to do in order to avoid that. Can be as simple as taking breaks or using multiple sessions to make it possible for the parties to think things through. But again, this is but I want to just keep in mind that this whole business of thinking fast and slow when we look at some of these traps, and just to run through just to refresh your memory as to what we're talking about. And I want to focus at least initially on a couple of them. I think as being more common and more challenging in many ways. But the whole list includes the following 10: anchoring, confirmation bias, projection or consensus error, framing, loss aversion, naive realism, overconfidence, reactive devaluation, selective perception, and self-serving bias. Framing is something we've talked about in a lot of these kinds of sessions. It comes up all the time in mediator training as something that's critically important in reflecting what the parties are telling us, validating their feelings and their positions and that sort of thing. Don't need to spend any appreciable time on that, but at least today, what I'd like to first focus upon is I want to talk about anchoring, and then I want to talk about loss aversion. Which doesn't get nearly as much attention, I think, as it should. But let's talk about anchoring first. And this is something that you all should be familiar with, certainly as mediators. And this is the psychological process where we form estimates of value by comparing them to something that we know or to a number that we've been exposed to or implanted in the brain, such that the number that we're exposed to now anchors or controls our thinking. And I've in the negotiation classes I teach every semester when I go through the top 10 psychological traps. I give the students a test asking them either to guess the population of Turkey or the population of Iran. It doesn't matter which country I use. but I'll give half the class, one reference figure and the other half another, unbeknownst to the students. Give one a number, a reference point of 40 million, and the others a reference point of 70 or 80. And when you break down the responses, uh, their guesses or their estimates almost always constellate around the numbers that they've been given, even though some of these students have already been exposed to the notion of anchoring. The thing that's particularly insidious about it is that even though you know about it and understand the phenomenon, when somebody plants a number in your brain, it becomes very, very difficult to ignore. The knowledge or ability to use anchoring becomes critically important when you're involved in a mediation as a negotiator, or if as a mediator when you may be coaching someone on what kind of an approach to take. The question you face is, do you make the first offer? Um, uh, to take advantage of anchoring, or do you wait until you have better information, it give you better opportunity to make a more reasonable offer or counter yourself. The the anchor will also control your concession strategy, what kind of incremental changes you may make, or negotiation positions you will take as you work your way through the negotiation or through the facilitation. Any comment on this experience, good, bad, or indifferent, you've had where you've had to deal with someone who anchored in a position that you saw as counterproductive and needed to be modified in some way? What experience did you have, and what did you do to counter the position that the litigants may have taken? Anybody? Al?
Well, I guess you might question the appropriateness of it at that point, but you don't want to discredit the privilege they have or the opportunity they have, and without trivializing it, at least respect it to start with.
Anybody else? I mean, that is certainly the case if you're going to you may take on what you think is an unrealistic number more likely in a private caucus. It may be easier to reality test it that way than it would be in public. Phil?
Well, I'm curious. I presume, Joe, that we're talking about this from the standpoint of the parties, not from the standpoint of the mediator.
Well,
So,
it could be both. I mean, take your pick.
That's a different problem.
well, from the standpoint of the mediator, if I were asking like one of the parties or both of the parties to consider a number, I think I'd want to do that in separate session, because unless, I mean, sometimes people just say, this is where I'm at. And then they've kind of thrown that anchor in, and the other side has to decide whether to play with that assumption or not. I guess as mediator, I don't want to be the one throwing numbers into the pond.
What about the question of making the first offer? You're asked by you may have a pre-mediation conference, or you may start out with with caucuses, and you're asked about making the first offer, or how the party asks you, how do you think I should proceed? What do you tell them?
I don't know.
I wanted to
I
answer.
don't know the answer to that question.
Yeah.
How do I think?
Kathy, I'm sorry.
Okay. Well, I was trying to answer the first thing. I haven't had experience with this, but I think as a mediator, you want to keep things as open as possible at the beginning, to like brainstorm and bring in new ideas and gather all types of options before you kind of settle in and people take sides and stuff. If someone throws out a number early, and you're thinking this is biasing things too much toward that number or something, I'm thinking the mediator could step in and say, well, let's think about other options first and not get too focused on this at this point. I don't know if that's leading the mediation too much the way you want it to go, but that's the best I can come up with how to handle it.
I don't think there's ever any downside in trying to acquire as much information as you can. I mean, in this field, knowledge is power. The more you know about the controversy, the more you know about the situation of your adversary, and the more you know your own strengths and weaknesses, the better off you're going to be. I think if you believe in the anchoring principle, and I think there's it is the evidence in support is overwhelming. It certainly makes sense if you can to make the first offer, but whether you do that and what it is really depends upon how good your information is. Now, you're right. Some people, I think Phil suggested, are just willing to throw a number out there. Well, if without any serious thought behind the number, the difficulty is that you may precipitate an impasse, way early in the game. And immediately get the mediation off track. And we I'm sure you've all seen this. It doesn't matter whether it's small claims or more complicated controversies where the plaintiff may throw out a number and somebody will threaten immediately to walk out, recognizing that the number is just clearly beyond the pale. And if that's an indication of the thought process, what's the point in staying further? Have any of you had the experience as a mediator of when somebody's come up with a number that really is unrealistic? Talked them down, or had the need to, or the opportunity to talk them down? Phil?
Mike, when I have had that experience, and I think it's incumbent upon the mediator to ask for a rationale. Why, what, how did you get there? What does that represent? Why do you feel that number is appropriate to this discussion? Those are the kinds of questions that a mediator can ask, seeking more information, putting meat on the bone, so to speak. It's not. I don't think it's that unusual for people to take advantage of that anchor and throw a number in, particularly when the conversation is about numbers. Throw a number in, whether that's realistic or not, just to see how fast the chain will unravel from the dock. So it's the other side needs to know more about where they're coming from. I think in order to have constructive conversation, you have to know what the foundation for that number is. Sometimes there is one, sometimes there isn't.
Anybody else have a thought?
I had an experience that it was
Oh, you muted yourself.
right. It was irrelevant. The money was irrelevant. It was two men who were they came through mediation because they had to, but it felt that there was more ego than settling, and they said, nope, we'll go to court. So sometimes they're so stuck in their that they're right or the other one is wrong that I'm not going to do it. I am going through the motion, but I'm really not doing it.
Mhm.
Yeah.
I think we've all had we've all had that experience. The challenge is to try and figure out whether and how you might get people to take a step back and reevaluate their positions such that they will continue to stay at the table and maybe talk it through. You're right. There's always going to be a certain number, I think, certain number of folks who are so pig-headed, so stuck in their ways, so biased and incapable of even considering the position of somebody else that you have to let them take their chances with the court and let the judge smack them around because that's the only way they're going to way they're going to see see reality.
Yeah, you know, Joe, I had a recent experience where the defense and the defense response to the plaintiff's claim was would ask the court for a summary disposition on the basis that there was a statute of limitations on the claim. So it's kind of hard to mediate the differences of the claim when the defense is one strictly of imposition of the law at that point. So I don't know what you do with that character.
There's really not much you can do. I mean, if it's your feeling, for example, that there's a clear limitations question
Yeah.
that somebody's not seeing, and you would expect that maybe if they were lay people, maybe they wouldn't appreciate it, but if people are represented by counsel, it's a limitation. It's a little bit like pregnancy. It's either there or it isn't.
That's right. Yeah.
And if the claim is time barred, it's not going to go anywhere, and the judge is just going to kick the case. There may be nothing that you can do for him. If there's something to argue about, then that's a different story. Then one is taking a chance, and you have to consider the likelihood of success or failure.
Yeah.
Let me, but before I leave this, the anchoring business, one thing that occurred to me that I might throw out for the benefit of other people, and this is, when you're facing a situation where somebody is thrown out, has put down an anchor that is really unrealistic or beyond the pale, and the opposite number is threatening to take a walk. They're telling you in private caucus that unless the other party shapes up, you're not going to stay. You're not going to stick with the negotiation or with the mediation. And this is a little trick that I learned from or that Dick Sobel uses. But Sobel is a longtime mediator, well known in the Ann Arbor community. And his trick when faced with something like this is to ask the aggrieved party who's ready to walk out, well, what kind of uh, if this number is unreasonable, what kind of an opening number would have been reasonable? In other words, ask them. You think this anchor is absurd? What would have been a reasonable anchor to start with under these circumstances? And then see if that number that is then thrown out gives you something to work with the other party to start to develop a settlement range that may work. So you can use the anchoring information, pro or con, to to your advantage in that way. Any parting shots on this? There's more that one could talk about here or share in the way of war stories, perhaps. But this business of who makes the first offer and whether you should is a delicate one, but it's an opportunity to get things off on a productive footing if you can get people to be more realistic about this. But let's leave this one be, and another one that I think I'd like to spend a little bit of more time talking about loss aversion because this enters into a great many facilitations in ways that we don't often think about. But the basic principles are fairly simple. For reasons, again, that seem to have an evolutionary basis, we feel losses more acutely than we feel gains. Loss is always is more painful than the gain is pleasurable. And it probably makes sense from an evolutionary standpoint to be more acutely aware of the danger posed by a charging rhino than the pleasure we might derive from the fruit plucked from a nearby tree. Again, bad news travels fast. Being perceptive when presented with bad news or with a threat is going to be far more important to survival than the pleasure we get from a gain that is not threatening. Yawning at stock market gains, panicking at losses. We're seeing this happen in the news over the last week. People running for the exits because of over-perceived losses. Another interesting point about loss aversion is that we're often willing to risk more to avoid a loss than we might be to obtain a gain. And we also tend to, again, because of our feeling that we feel losses more acutely than gains, we tend to regard our own concessions as better or more valuable than the concessions that the other side may make. First cousin to loss aversion, and that comes into play quite frequently, is what's known as the endowment effect. the natural tendency we have to regard uh, our property as more valuable and commanding a higher price because it is our property than your property may be. Um, we've all had this experience. It, it could involve sale of an automobile. More often than not, it involves the sale of a house. Um, you may have had the experience yourself or with somebody in your family or when you were buying a piece of real estate, um, noticing that people were unrealistic about the price, unwilling to let go because it's their home or their house. Um, More real estate, more astute real estate agents, will caution you if you're serious about getting rid of your home, to stop thinking about it as your home and to just think about it as a house. Uh, we'll look upon it as a piece of real estate rather than as a piece of your identity. You're more likely to set a realistic price and get rid of the home more quickly than if you let the endowment effect take hold and push you to a higher, it may be more unrealistic price. Um, Another relationship to the concept of loss aversion is the concept of sunk cost bias. Uh, if we've invested time and money into something, we're most reluctant to give up on it and cut our losses and turn back. For mediators, the trick is going to be to get the parties to look at the big picture. It may be better to sustain a loss now for greater gain in the future. And the challenge is to try to frame the loss as a gain. These are some of the basic principles. And I think that along with them, what you need to consider, or another, I could list as a third cousin, first cousin endowment effect, second sunk cost bias. The third is the natural preference we have for the status quo. Okay. In other words, our natural tendency is to avoid rocking the boat. And this preference for the status quo makes it more likely that you're going to feel a loss, a deviation, a negative deviation from the status quo more acutely than you will a gain or a net increase that goes beyond the status quo. One of the one of the more amusing illustrations of loss aversion and Phil, I know, is a golfer, but I think anyone would appreciate the illustration. The research indicates that golfers expend more energy and more concern over when they're shooting on any given hole for par than they would be if they were making a shot that would result in a birdie, a shot that would result in a score below par for that particular hole. The idea being that since par is the reference point for golf, anything below par is perceived as a loss. But the gain of a birdie is the benefit you get from a birdie or the pleasure you get from a birdie is not nearly as effective as the negative pain you feel for shooting below par. Um, it's a kind of a simple but still dramatic example of the effect of loss aversion. Um, the couple of additional points on the endowment effect, again, to illustrate how it works. It appears that, or the research would suggest that giving up a good bottle of wine from your cellar is more painful than getting an equally good bottle of wine from somebody as a gift. Another simple example. There doesn't seem to be any, if you're dealing with a purely the purest of commercial transactions, where there's an even exchange, loss aversion doesn't come into effect. For example, if I ask you if you have if you can change my 10 with 10 single dollar bills, it's not going to have any effect. But if what we are talking to exchange, I have some use for that enables me to attach to it. Again, it would use the example of the wine. Um, I may be reluctant to give up a bottle of my wine for an equally valuable bottle of wine that you may have to offer. Again, because I tend to regard the loss more acutely than any gain, particularly if it's something that I'm gonna use. Kahneman, one of the points that emerges in Kahneman's book, Thinking Fast and Slow, is that this what he calls the asymmetric intensity of motives to avoid loss and to achieve gain, you're going to find everywhere. This goes well beyond our negotiations or mediations. Witness the example of the bottle of wine, or golfers being more concerned about hitting par than shooting above par. The important thing to keep in mind from the standpoint of mediation or conflict resolution here is that the party's concession strategy and the approach you take to helping them make concessions is going to be colored by loss aversion. Your concessions are my gains. My concessions are my pains. All right. In other words, anything that I'm giving up, I'm most likely to perceive as painful, and I will perceive something I get from the other side as being a gain. The effect of this is the need for exchanges or concessions to be made in reciprocal fashion. If I'm going to give something up, I need to get something of equal value from you, and vice versa. Any thoughts about how you've come upon this as a mediator, where you've seen perhaps painful examples of this a reluctance on the part of a party to give something up because it's been perceived as a loss. And the challenge that you faced in order to characterize the loss as best you can is a gain.
The
I have an
traditional,
example. Go ahead, Al.
well, the traditional one is the mediators pointed out that the loss you're going to experience by making this concession results in the gain of the peace of mind and the elimination of the anxiety and the uncertainty of going to trial.
Uh, excellent, excellent point. And I think one we don't, I think while we're all aware of it, we may not be as ready to jump on that. I mean, we've all used this, I think, from time to time to recommend a party or to suggest the the value in a settlement that certitude and peace of mind are ultimately going to be far more valuable than taking the taking the risk of going to trial. And whether you settle or where you go to trial is another good example of loss aversion. People are willing to take the risk of trial because they see this perhaps as a greater gain rather than the real opportunity for loss that it is. Phil, you had your hand up. You got to unmute yourself there.
That risk aversion that's associated with, the cost of trial or the risk of trial, what have you. I'm gonna suggest that that's one of those, quick reaction kinds of things. People seldom, when you say, well, what's gonna be the cost of going to trial? Well, I'll either win or lose. Well, it's not that simple. And if you back away from it for a moment and say, okay, there is the win-loss, decision, then there's the cost of trial, then there's the both economical and, psychic. There's lots of issues involved in that decision. And one of the gambits that our friend Tracy Allen uses all the time is the loss of control. What are you gonna? Okay, if you're gonna go to trial, that's your prerogative. You can do that. What happens to your influence on the outcome then? You've lost it. It's gone.
Mm-hmm.
By the same token, though, while we're sitting here and we're talking about options and we're talking about considerations of cost and risk and what have you, you can manipulate that, and you can use those factors to address your needs and your interests, and if you're thoughtful about it, the other party's needs and their interests, and you can craft something that is reflective of that. If you take your case into the courtroom and you put it before the judge or the jury, you get their answer. And it may be reflective of your needs and interests, or it may not. Mm-hmm. And one of my all-time, win your lawsuit, lose your money.
Mm-hmm.
Can I jump in as well?
Yeah.
I think this fits into this part of the conversation. I recently assisted with a small claims matter in which a homeowner contracted with some folks to do some home improvements. And the contractor discovered there was some other work that needed to be done before the actual home improvement task could be approached. And for whatever reason, things went south and the homeowner ended up suing the contractor. I was intrigued by the contractor's position around being the loss aversion, like if you want to this homeowner had paid a deposit and wanted the deposit back, and the homeowner asserted there was some additional damage to the home and got some estimates and wanted that money too. So this lawsuit was in small claims court, so it was appropriately placed. But the contractor did not want to settle and felt strongly that the receipts and the time that was put into this home was worth it. Like, I should not refund you anything because we did some work, but we did not do the work of home improvement yet. And when the mediator asked the question, what does this loss mean to you as a contractor? The contractor was very passionate about, I'm losing this job, I'm losing money, I invested money into this project that I can't recoup. I had to pay my people for the work that they did. So it was going back and forth, back and forth. But I think the magic question for the mediator, who's not on this call, but did a great job in framing this question, what does this loss mean to you? And this contractor had a chance to talk about a bigger framework of being a small business owner, tough economy, the uncertainty of the economy, and just needing not to lose everything on this job, and thought by going to court, maybe they would settle and there would be no money exchanged. That's what he hoped. Like, they did some work, there's no refund in place. So I just wanted to toss that out as thinking about this loss aversion. I thought it was a really great question. What does the loss mean to people? Are people able to negotiate their range of loss? Like, I can't get the 7,500 or whatever the higher limit is of small claims. I'm gonna lose that, but I can lose less if I go to court and only have to pay $2,000 or something like that. You're still losing, it feels like, but they're losing less. I hope that makes sense to folks, but it was just one of those small claims cases that really stood out in terms of how the negotiation went. It wasn't about what we were gaining. It was about how do we mitigate what we were losing.
Mhm. Well, I think one of the important points in what you're saying, Belinda, is that the concept of loss oftentimes is going to go well beyond dollars and cents. Okay, it is going to get into questions of identity, face saving, that sort of thing that may be less tangible, but just as important. I think the important thing or the challenge is to be able to get all these things out there, or to be able to enumerate them so that you're able to put all the cards on the table, so to speak, so that you know what you're dealing with. The same thing is true in terms of characterizing these gains, as Phil mentioned just a few minutes ago, or Al brought up. Sure, if you go to trial, you may be able to gain A, B, and C, but isn't certitude, peace of mind, control, are these things ultimately going to be more important than taking the risk that you may get more of what you want when you go to trial.
And I'm also wondering if the reality test, if you have A, B, and C, A being the most optimal outcome for a participant, and C, D, and E are less optimal, but in reality testing satisfies those intangible needs like reputation of my business, having, I'm a small business owner, I have high integrity, and I don't need that to be, the thought of paying out the optimal outcome for the homeowner means that I'm a, shady business owner. I don't do a good job. So I think as I'm listening to you and even reflecting on that case, it felt like that linear structure that we often, want to use for mediation had some things in the peripherals that were equally, if not more important to the participants. And small claims court, just that small stint of time that I was helping with cases was a reminder of how the high emotions of these transactions are. Some of the examples you've used, I don't know if litigants in that setting could even relate. I just was really reminded of how important, landlords need their back rent in order to do maintenance on the property. How important, in this case, the small business owner's reputation was. So just another thread of thought in how to help people really weigh and tap into what loss aversion means for them. What does loss mean for them, and not sticking to those real tangible things that I think sometimes we get stuck on.
Yeah, well, this is one of the reasons why out of these top 10, as I was reflecting on them, I thought a more extended discussion about this would be fruitful, because it's too easy to overlook the need to seriously evaluate where the gains and losses are, and how each party sees gains and losses. And I mentioned this earlier, and it's a little bit more nuanced, maybe to keep an eye on, and that is the status quo bias. Okay. People often talk about being put back in the position that they were before. They want to be made whole as a result of the mediation. Well, what does making them whole look like? They had a view of the status quo, that they're now being, and go back to the example of your construction case. The status quo may have been the contract. Any deviation from the contract, which would result in doing more work, paying less money, is going to be seen as a deviation from the status quo, and the bias is going to be in favor of the contract. You see the same kind of thing in labor negotiations. Another good example. What's the status quo in a labor negotiation? It's probably the existing contract. Any improvement from the existing contract is seen as a gain. It's going to be beneficial, won't be felt nearly as acutely as taking away something from the existing contract, which is far more likely to get the employees upset. To me, the moral of the story, or the challenge here, is to really do a more thorough analysis, and consider in any negotiation or any mediation, how do the parties see their respective losses and gains, because it's really going to determine with their likelihood of settling on beneficial terms. And I think this is one of the reasons why this whole notion of loss aversion is one reason why interest-based bargaining, getting to yes, Fisher and Urey, is a popular and very effective form of negotiating and dispute resolution. parties have a far easier time dealing with an expanding pie, where you can allocate gains without much difficulty, than they do when you're dealing with a shrinking pie, where they see the negotiating as being zero sum. A gain for me is a loss for you, or vice versa. Um, so this is another, I guess it's another way maybe of looking at interest-based bargaining is a way to get all hung up in loss aversion. If you can find a way to uh, not just characterize the individual situation as of being repeated, of one of gain, uh, try to characterize the entire conflict, or find a way to expand the entire pie so that it isn't just a zero sum game. Any other reactions from anybody as to how they feel about this, or how uh, their own your own experience?
Just one example of one of those rare occasions when you can have a gain in small claims was a situation where a contractor was suing for the balance of payment on some work was done. The homeowner was questioning or the quality, not the quality, but the completion of the work. And in the final analysis, they agreed that the homeowner would allow the contractor to use a different material, and the contractor agreed to do that, and the homeowner would pay the balance owing. So there was a gain situation, which doesn't happen very often.
Mhm. Anybody else? Let's see. There was somebody else in the any other experience with the phenomenon that of gain and loss that you would like to like to share? In general terms, let me pull up the screen again here. Where is it? Why is it not working here? Why have I lost my?
But Joe, if it's a wood burner, throw on another log.
I'm sorry?
I say, if that computer is a wood burner, throw on another log.
Yeah, I don't. What do I want? There we go. Let me go to. I want to just spend with the time we have left. Um, we could spend time on each one of these, but as I said, I thought the anchoring and the loss aversion might be a little bit more ripe for discussion. So the question is always, what do you do? I mean, how do you how do we avoid the traps, or better work with them, beyond just knowing about them and how they operate? I think most of us can see the value in the need to step back, um, to bring a thoughtful analysis to bear to the situations we have. What strikes me is that as I reflect on these traps, is how often you can get around them simply by taking the time giving people time to process, um, what's going on, and to process the issues and the need, the need to come to some kind of resolution. And I'm thinking, and I said, Nancy, and I have had this experience in domestic relations mediation. I think there's a reason why, unless you have an unusually conciliatory couple, you can't, regardless of the complexity of the issues, you can't get them done in one session. They almost always require a couple sessions, sometimes more, simply because the parties need time to process what's going on, particularly if you engage in you as a mediator, you engage in reality testing, or you're aware of these traps uh, being operative, and affecting the behavior of the parties. Somewhere in this, in the PowerPoint, I make the statement that research shows that the biggest obstacle to settlement or to reconciliation is the inability to see the situation from another person's point of view. You see this operating in spades in domestic relations cases, where the parties are at loggerheads emotionally and otherwise. And it seems like it's only with the salutary effect of time, giving them an opportunity to process these things, are they able to step back and to make a more beneficial analysis of loss and gain, for example, and to see that, yeah, they really are better off settling. Yeah, the kids really are better off if mom and dad find a better way to relate to one another. But in almost all of these cases, it seems like slowing down and taking time has a salutary effect, regardless of your knowledge of the intricacies of these traps. Phil?
In your slide regarding loss aversion, the very last point, if you could humor me. I'm just curious, does anybody have, say the very last point, mediators get parties to look at the big picture. Does anybody in your experience have the magic bullet, the question that provokes the parties to sit back, reflect on where they are, where they think they want to be, and begin the process of looking at that, at their conflict from the 10,000-foot perspective? Does it? I'm interested. Does anybody have that question? Does anybody know? I mean, Nancy, you've been doing this a long time. Joe, you've been doing it a long time. It's particularly important, I think, in domestic relations cases. Sometimes that question, if you have it, can be fundamental to the small claims process. I don't know what it is. I wish but I'm happy to hear versions of it, whatever they are.
Nancy? Phil's calling on you.
I wish I had that magic bullet. I think we all do as mediators. It often takes a lot of questions in order to get to the goal that one is attempting to attain.
Yeah, unfortunately, I have to agree. I have to agree with Nancy. There's probably no one question but maybe after a series of questions, you can get the parties to look at the bigger picture. And I really think so much of this is getting, and this is why I emphasize the importance maybe of multiple sessions, slowing things down and taking time. Our natural tendency is to the parties get so hung up in their emotions and their point of view that it achieves a reality of its own that it doesn't deserve, you know. The Buddhists have kind of a way of looking a way of stepping back and looking at these things. One of the things that Buddhism, well, not just Buddhism, but other world religions teach, is that you are not your thoughts. Most of us have a very difficult time coming to grips with that, the notion that that our thoughts are not our identity. There is more to you than the thoughts are like clouds which float along float across the sky. The problem is, and this was something I heard from one of the Buddhist practitioners pointed out. The problem is, although thoughts may be like clouds, we tend to give the clouds roots and tie them down and pin them down to the ground. That's it's a way of looking at what you see people doing. When they get so hung up in their emotions and their view of how difficult the other party is, or how hateful the other party is. Well, I mean, you see this. We certainly see this in domestic relations. How destructive the anger that people have, or the obsession that they have about the behavior of another party, it dramatically affects their entire life for the negative. Whereas if they adopted a more realistic point of view, one that takes in the big picture, they would see how destructive this thought process is. I mean, this is getting at something maybe that goes way beyond your normal, mediation or whatnot, because it becomes more we're almost into more transformative type stuff. But I really believe that until you can get people out of this self-destructive way of looking at things, until you can get them to see that what the pleasure they're getting from revenge is ultimately far more destructive and far more of a loss than a gain. You're not going to make any progress in the mediation, and more importantly, they're not going to make any progress in the relationship. So that's a very long way of unfortunately, Phil, acknowledging that there is no one magic bullet, that we're all too complicated to be susceptible to an easy and quick resolution. Anybody else want to take on offer Phil the magic bullet?
I don't think there's a magic bullet either, and I've never thought there was. I mean, some of you know me well enough to know that I got involved in mediation academically in the mid-90s. So this journey of, oh my God, 30-year journey this year, I have seen the ebbs and flows of people. And I tend to think about if I'm mediating, facilitating, whatever I get to do, even if it's, facilitating a meeting with business people around the DRC. If I'm in that space, I think about all that the parties bring with them to the mediation or to the discussion. I've been programmed to think that way and to think about the ecosystem that they swim in from day to day, especially when I'm thinking about the cases that we work on, and how the challenge, I think, as an alternative dispute resolution practitioner, we have the rules, we have the process, we have some court rules to back us up, we have the standard of conduct that supports the work that we do and endorses the work that we do. And that's it, So how do we adapt to some degree in a way that brings the parties closer to the process, and maybe us as the facilitator through trust? If they can trust you, they can trust the process, or if they can trust the process, maybe they'll trust us as mediators, right? So how do we do that in a way that allows them to come and engage in the way that Joe is suggesting and Phil and others are suggesting? I think this work has become challenging over time as our ecosystem is becoming challenging. Again, I sat in a few small claims cases, which used to be 1 hour and out data-wise. I look at the data. My job is to, report the data. Part of my job is to report the data so I could see the data. It used to be 1 hour. It's beyond an hour now. I don't think it's all because of being in a virtual space. I think people are just bringing more baggage, if you will. That's my word, baggage, to these sessions. Life is happening in ways for them that we may not understand. And I think it's harder for people to compartmentalize their lives in ways that make them only present for the mediation. I'm working on a particular case that is a child protection case, and everyone was undone when the biological mother didn't show up, but she was doing other things compliant with her court case, and she just could not make that time, even though she said she would. And I felt that it was my responsibility to bring the temperature down and give the parties a reason to reconvene later. It wasn't that she was flipping us off. She really just could not make it. And she called, once her attorney got in touch with her, it was a legitimate excuse. And she said, I'll come now. And I thought, no, she's not going to be in a good headspace for this kind of conversation. So let's reschedule. And we have time to reschedule. So I'm sharing that as an example of how I feel the responsibility lies on us as mediators to really have enough insight, compassion, empathy to help the parties trust the process and trust you as mediators to engage in a different way. If there is a magic bullet, maybe that's it. I'm just finding, when I look at the data, I'm seeing some real changes in our data from pre-COVID to now post-COVID. Settlement rates are down, not drastically, not in ways that make us, that scale is calling me. But I'm just noticing some differences. Small claims cases needing 2 sessions. Average time is about 90 minutes now instead of an hour. And you all, may know that we do a higher volume of small claims cases than we do of any other case type. So I'm noticing that. In the civil space, it's just a little bit different. So internally, we're trying to prepare ourselves. And And I think we have to really think about what other tools do we need to be tapping into and learning and understanding about people. The other cautionary thing I will say to us, I say it internally at the DRC, we have younger generations coming into this space. We have millennials who are the subject of the court cases now. We will have, what's the next generation down? Gen Zers who will be coming into these court cases. We really have to think about how we engage with them because they have a lived experience that's different from all of us on, or most of us on the screen. Their life experience has just unfolded socially and economically has changed, different from ours maybe. And they have a different expectation. So when they come to training and when they call the center, they have a different expectation of what service looks like. So I've challenged the staff and I'm challenging all of our volunteers. Let's start thinking about what materials we need to be absorbing so that we can continue to do a great job in working with the public. At the community centers, we accept almost every case that comes. So we're seeing a real diversity in our clients. In private practice, you have a little bit more control of that, who comes to your service. So I think we need to, maybe take a step back and see what else, should we be thinking about? I'm thinking about how trauma plays out in conflict. So I'm doing some of my own learning and studying and researching that a bit because the numbers are telling me something. And how do we prepare and what should the 40-hour training look like? Any supplemental training? I think it's worth it. The stuff Joe is bringing to our consciousness around what happens in the brain around, the psychology of negotiation. I think we need to take a deeper look into that too. And then there's some information just on the generations of our society and what their lived experiences are telling them and how they move through life, negotiating, engaging in services, and living in otherwise. So I think there's a lot of room for us to continue to grow and evolve in this subject matter. So I'm sorry, Joe, I didn't mean to take it over, but I just wanted to
No, it's
put that out there.
it's a more than suitable segue to a conclusion here. I just wanted to echo on top of all the other challenges you mentioned, and you've kind of outlined, you throw on the what to do about Gen Z. I mean, what to do about the young people who are now at the front of the cohort. They tell me the average age of the students in law school, and it's not going to be any different anywhere than it is at Michigan State, is about 23. More women than men by a slight percentage, although that's increasing. The difference between what these kids are dealing with and their environment, their ecosystem, as you described it, and mine or ours, we may as well have been born on another planet. From is a lot of these kids, and it's a real challenge to deal with them, given the uniqueness of their upbringing and their situation, their exposure to social media.
Yep.
I mean,
You're absolutely right. I am blessed. I am married to the last of the boomer generation, and I'm the parent to a Gen Zer. And I personally am a Gen X. So we have a very interesting household over here as we talk through social issues and expectations. It's a very interesting household.
yeah.
So it's 1 o'clock, Joe. Do you have
But
anything?
hey, 1 second,
Okay.
one parting shot. This is why I brought this screen up.
Oh, okay. Yeah.
Notwithstanding, I really believe, and I would just wanted to emphasize this. I misspelled it here. Leonard Riskin is one of the mediation advocates and ADR gurus who advocates mindfulness as a route to better negotiations and mediations. And that's kind of that's what we've been talking about here. Cultivating the capacity for non-judgmental awareness of ourselves and other people. I think if you can do that, if you can pay attention, be present, and develop insight through non-judgmental awareness of ourselves and others, you're going to be way ahead of the game in terms of dealing with all of these challenges, whether they're 23-year-old kids or otherwise. I mean, you got to reach. I think we got to find a way to deep down to dip deep enough in ourselves to touch that place that really is we share in common with everybody else, regardless of age, race, whatever the background is. There's still a fundamental identity that's very difficult oftentimes to reach. But I think unless you reach it, you're ultimately not going to be successful, or at least as successful as we should be or could be. Anyway, that's the last parting shot and pitch for mindfulness.
Well, thank you, Joe. You can stop your share.
All right.
Screen.
Where did I go? Here we go.
Okay. Thank you, Joe. And thanks everyone for your engagement in this Lunch and Learn. We'll send out a note, but this will be the last Lunch and Learn for the season. We'll restart late summer, early fall, October-ish or so. I made that decision because I think the staff and I needed to take a step back and recalibrate. We've added on 2 new staff people. We need topics, subjects, and we need to reconfigure what does this space look like. And we've heard from some of our volunteers that being in person, they miss that and they find a lot of value in that kind of in-person connection. So we're going to use the rest of the spring and summer season to really figure out what our capacity is and what can we offer so that we can make this a rich learning experience, and more importantly, a community of practitioners. I think we lost a little bit of that since we've been doing so much virtually. So be patient with us and as we move through that process, and please offer any ideas that you have, subjects, speakers. Many of you are connected to other groups. Please offer those ideas to us so that we can take it under advisement, do the outreach for it. And of course, cost is always a big deal for us. But that's what we're thinking about. And we're also thinking about frequency. Is it a monthly event, bi-monthly? So give us some feedback. Tell us what will work for you or what you think this experience can be for you. The Lunch and Learns were designed we're designed for the volunteers, the staff. We're here, but we really want to do this for you all. Before we depart, I just want you to know that the DRC has a few events coming up, trainings and events. You should get an email that came from Jermaine, our blast email, but we have a community circle coming up on the 19th. We have Brian Pappas is going to come to town and do domestic relations training for us in May. If you know folks, if you want to be a part of that, or if you know people who are interested in that, please send them our way. If cost is an issue, send them to Jermaine and I, and we can renegotiate that. We really want to add to our pool of volunteers. What else is coming? And we have the big Restorative Justice Summit in October. So we're excited about that. We've just pinned down our keynote speaker, Afania Davis. If you are in the RJ world, her name might ring a bell to you. And anything else I'm missing? And it's all on our website, so you can check it out. And as I said, Jermaine sent out e-blast last night or this morning.
Belinda,
Yes.
just wanted to confirm that the community circle on the 19th, that's for everybody, general public. And
General public, anybody can come. I think we
Okay.
had 15, 18 people so far registered, but anyone can come. You don't have to be a DRC volunteer. It will be held at WCC, Washtenaw Community College, and that it's Garrett's restaurant, but they don't use it as a restaurant anymore. So it's a good meeting space for us, and we'll have lunch as a community. So we're looking forward to that. Oh, and the Unity Walk is coming up in June. I'm sorry, I forgot about that. So we'll have a way of connecting and convening in the community. So a number of things coming up over the next few months. Please check it out, participate as you can. But for Lunch and Learn, we won't reconvene here until September or October, and we're still working through the calendar on that. Okay. Take care, be in touch. Thank you all.